So one of the things that most people know about are non-disclosure and invention assignment agreements. I think everyone should sign them in a startup, particularly if it's a technology-based startup. So that means your founders, that means your employees, that means any consultant that you have ought to assign all of the intellectual property that they have created or will create for the company to the company, right? Otherwise, the company doesn't own it. We see a lot of times where a founder will create a lot of IP, form the company, start to hire employees, and even get to a round of funding. And maybe we're on investor side and we start to look at the diligence and we're like, well, who owns the IP? I'm like, well, the company does. I'm like, well, it says it's in Paul Smith's name, right? That's not good, and then that has to be assigned. So it's very important to do that early on. Make sure that anyone who's working with the company assigns the intellectual property to the company. That's another reason to form early. Trademarks, you want to check trademarks very early on. I'm not saying to do, when you file, there's two portions here. There's a filing of a trademark and then there's checking of trademarks. So oftentimes founders will agree on one thing and it's the most important thing that they agree on, which is the company name. And they love it. And it's going to be the brand and the name. If it's that important to you, before you go do anything, at least do a quick knockout search. Go on to Google, go on to the USPTO. Right? Figure out if someone else has it or is using it. Because you can file in Delaware, and it might be available under Delaware. That doesn't mean that you can use it. Right? Just because it's available to file under doesn't mean that you won't be violating someone else's trademark. So before you spend that time and money do that, another option is to form the company under some other name, any name that you choose or think is fun, and then file for a trademark once the brand becomes it comes into the marketplace and it's become more ubiquitous. Did you have a question? Oh, sorry. The clearance search is something that's to the next level of security, right? It looks at, basically, it will look at all of the potential trademarks that are out there that are either filed and other ones that might be used in commonplace for which there might be common law protection. And it will tell you whether or not you can file the trademark and the success. That costs a lot more money. These clearance searches usually run from, I think $800 to $1,000 just for the search itself. There are outside agencies that provide that. Then lawyers will look at that. I don't recommend this for the startup unless your brand really depends on the startup. But what I do recommend this is before you file a trademark, you want to clear it and make sure it's done. Otherwise, you're going to spend money and time filing it, and you won't know what your likelihood of acceptance is. Patent applications, I get a lot of questions about whether or not people should file a patent application, when that's appropriate, or whether just to leave it not in the public domain. Once you file something, after 17 years, it can be revealed. Here's my view on patents. If it's something that might be patentable, and you're thinking about it, it's a low-cost methodology is to file a provisional patent. You'll have a year to follow up with that and kind of confirm it before you do that. And the reason to do this is maybe just to protect yourself against patent trolls. People are looking at your technology and saying that you violated their patent. The best defense on that is to say, no, I have my own patent, or I have my own patent application, and by the way, you're violating mine. So let's just let each other be, right? And enter into what it's called a standstill agreement. That's the best way to deal with that. And that's the reason why I'll often recommend, go file a patent. Accurate records are so important with respect to any intellectual property. Notes, records, if you need to establish those dates, it's important to keep those records accurately. I think one of the best pieces of advice I give to startups is start off with a Dropbox or Box.net, right from the inception, and just sort of categorize each folder. Anytime you do something for the company or even have emails, put them in the folders. Just use that as your routine, and that's your file system. What that does is it creates an easy way to share information with co-founders. It creates an easy way to share information with attorneys, and it creates a data room eventually so that when you do a financing or an M&A transaction, your data room is essentially already organized. and you can just give people access to it. It'll save you a lot of time and money. But you want to do this and keep the appropriate intellectual property records in there. Same thing for copyrights, domain name registrations as well. One of the things that we see a lot are you form the company, you get mycompany.com, and they're like, oh, I got it, it's an awesome URL, and you'll sign, you'll form it under your own name, and it's not under the company's name, or the company wasn't formed. So we'll go into a transaction, we'll start to look at who owns what, and it's often formed under the founder's name, it's never been transferred. So keep an eye on for that, and if you form it under your own name, just remember, when you form the company, transfer it. Licenses of technology and software, extremely complicated. I don't recommend you do this on your own if it's at all a very important license that you're negotiating, or if it's exclusive. You want to have an attorney helping you out with that. That said, if your business model is a SaaS business model or you're licensing software, get a really good set of forms that you can use over and over again. Some of the things to think about inside of those forms, the provisions that you want to focus in, are non-competition, right? You can't use this information, can't compete with me if you're a licensee. You can't assign it any further. You want the ability to terminate, right? It can't be perpetual licenses. Those are bad things, and when you get investors looking at the company, they may view that as something that sort of is a tick on value, right? Because you have to perform under this license to another party, and usually early on, your early licenses are not in your favor. As the company grows, the licenses will be more in your favor, right? But at the first inception, the terms aren't really great for you. Exclusivity provisions. You want to avoid exclusivity from your perspective as much as you can. Consulting and development agreements. Most startups will start off with a consultant, and particularly for intellectual property, and you might have a full stack developer working on the back end. You might have someone doing front end development for you on these agreements. Carefully negotiate who owns what, and when you're negotiating who owns what, also negotiate a license to underlying IP. So take the following example. Dave is a full stack developer that is developing a series of programs for me, and he's using his own internal algorithm that he's developed in order to do this, right? It's a methodology or a tool that he's used. Now, I have the end product, but do I have a license to use that tool, right? That's what you want to make sure, and you want to make sure that you get everything that you need to use that tool. And sometimes you'll miss that. So just getting kind of the front end of this isn't all that's there. You want to dig a little bit deeper into the back end and make sure you have all the underlying licenses that are necessary. Websites, privacy policies and terms of use are important, particularly depending on what you're doing. Social networks, data collection, you want to consider that. And also, it's always good to look at your competitors in the space and see what types of terms they have, right? That's informative. It's always on the bottom of the screen.
I'm going to add to that. In a university environment, students are going to class. They've got other responsibilities. Most of them are not working on the venture full time. They're in their dorm rooms at night. They're working on it in their free time. But it's just as important when you have the real semblance of a team coming together to have these conversations with your co-founders / roommates and try to figure out what role are we going to play in this startup. If you want to have, we understand that some of you may leave, and that's why we have a vesting agreement in place. I mean, I think it's even more important to have those conversations as early as possible in a university setting, because here in my role, I see so many founder disputes arising from these kind of situations. And if you look at all the classic cases that have made the mainstream media, the Facebook cases and the Snap, I mean, almost all of these situations that you hear about started in a university environment. So many of them.
That's a great point, Dave.
But bit of a follow-on question from that. Say you work at a company, so you've graduated, you work at a company, you've signed an agreement with a company saying everything you develop for them is their property, and then you know, on the weekends you kind of work on your own stuff, you kind of come up with a website or whatever it is. How does the intellectual property work there?
So that's a terrific question, because that happens all the time, right? And it happens with Google all the time, right? Particularly Google, right? Because they're all working on something else afterward. Google's considered the fifth year of college in some respects. But I think you want to take care to separate the work environment, right? Don't work on your company at work, you know, at your offices, and don't use their technology. Don't use their computer, their software and things to do that work. And you separate it. That's the first level, right? And that assumes that it's a disparate project. But you know, if you're working on something that's very similar to what your company does, you may have to look very carefully at your agreement and whether you're violating any type of restriction, right? You know, there could be a confidentiality provision or a non-use of confidential information where you can't use anything that the company had or in the formation of your company, or there may just be a straight out non-compete in which you're not allowed to form anything that's competitive with that. So that's the second layer. You want to look at what your restrictions are or otherwise. But that's where record keeping becomes really important too. You know, make sure that all of those records, the nights that you're working on it or money that was spent, you have those receipts. It's, you know, you didn't pay for some shrink wrap software, you know, and put it into the company account, you know, and have them reimburse you for it. You paid for it out of your own pocket. This is where things go wrong. And so you want to keep those records if you're going to do that. And check with your company's policy. I know Google has a policy that, you know, with respect to this stuff, and a lot of companies are, you know, particularly tech, you know, flavored companies are doing the same thing.